On July 22, 2025, India witnessed a rare constitutional moment. President Droupadi Murmu invoked Article 143 of the Constitution, seeking the Supreme Court's advisory opinion on a sensitive issue. Can the President and governors be judicially compelled to act within fixed timeframes on bills passed by state legislatures? This unprecedented move stemmed from the Tamil Nadu government's challenge against Governor R.N. Ravi's delay in granting assent to 10 state bills. In response, the Supreme Court delivered a landmark verdict on April 8, 2025, enforcing time-bound action from the Governor and President, a first in Indian constitutional history. Under Article 143, the President can refer questions of public importance to the Supreme Court. The court's opinion is advisory. It guides but does not bind. Yet historically, such opinions have influenced policy and governance deeply, even though they cannot reverse binding judgments passed under Article 141. The distinction is crucial. Article 141 makes Supreme Court judgments binding. Article 143, in contrast, does not grant the President power to override judicial decisions. This was firmly reiterated in the Cauvery Water Disputes Tribunal reference of 1991. Advisory opinions cannot be used to seek review or reversal of a judicial verdict. While a presidential reference can't actually change settled law, it can, initiate transformation. The 1998 reference, for example, led to refinement of the collegium system. Similarly, advisory insights influenced reforms after the 2G spectrum case. So, while these opinions aren't binding, such views often shape future judgments and policies. The issue at stake here really reflects deeper tensions in center-state relations. States argue that indefinite delays by governors erode legislative autonomy and disturb cooperative federalism. The April 8th verdict ensured timely decision-making. Now, the presidential reference tests whether that principle actually holds constitutional weight. The court may choose not to answer a reference if it lacks constitutional significance, as we saw in the state of Gujarat versus President of India. However, when the reference concerns, fundamental issues like executive timelines or constitutional conventions, the court is much more likely to respond constructively. Technically, no. The April 8th ruling, delivered in the court's adjudicatory jurisdiction, remains binding law. Any reinterpretation must come through review or curative petitions, not an advisory route. Still, if the court nuances its view in the reference, it could pave the way for fresh constitutional challenges. So, in 2012, the Natural Resources Allocation Opinion clarified that Article 143 could actually be invoked even after a judgment, as long as no party's rights are affected. Precedents show that, while advisory opinions can't really change verdicts, they can definitely help clarify those unresolved constitutional ambiguities. The reference here touches on three core constitutional principles: rule of law, federalism, and separation of powers. Can timelines be constitutionally mandated? Can executive delays be judicially reviewed? These are, honestly, not just legal questions. They really define the contours of India's democratic accountability. Presidential references are meant to be instruments of deliberation, not confrontation. As India's democratic institutions keep evolving, constitutional conversations like these keep reaffirming the living nature of the Constitution. Whether or not the April 8th ruling is modified, the reference ensures deeper scrutiny and, honestly, stronger clarity on executive accountability. In the end, the Constitution thrives not on rigidity, but on reasoned dialogue. The question isn't just whether the reference can change a judgment, but whether it can actually refine our understanding of democracy itself.